Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm reviewing a book from Jordan Publishing which is Insolvency Legislation, Annotations and Commentary, now in a new 5th edition, and it's been written by Lewis Doyle, Lewis Doyle and Professor Andrew Key. It's this book here. We'll have a look at it in a minute. We have reviewed it before. It's an important book, and one that I think will assist everybody in this very difficult area of insolvency legislation. It's also available as an e-book. Now, Elizabeth and I talked about the book, and we discussed the contents and what the new edition, the 5th edition, has. And so we've given the title for our review the following: Insolvency Legislation Clarified and Explained, a definitive reference, now in a new 5th edition. Let's have a look at the book first. Blue cover there. It's a heavy book. It's a paperback. There is the spine, and there is the back of the book there. You can see there's a lot of information, including some recent cases which are referred to. You can see the back of the book has a standard index. It's done by page numbering, not paragraph numbering, the index. Then you've got a whole series of various statements running all the way through the book. Let's go to the front of the book so you know how it's actually structured. There is the front page, which shows you the people involved. There are a lot of people involved in this. There have been a lot of contributors, and I can't mention all of them by name. They are, of course, listed there. You can see the names there. Then you've got a dedication, which I always like to show, which is there. And then you've got a foreword from Alistair Norris of the 4th edition. That's the previous edition. And then you've got a preface, which is always worth reading to get some idea for the 5th edition of what the two authors are talking about here. There is, of course, the Insolvency Online service by Jordan's, which is referred to again in the preface, and that's available if you go to the Jordan Publishing .co.uk website. And that, in fact, the actual preface is dated March 2016. Then you get the contents section, which is relatively straightforward. This is actually Insolvency Legislation, Annotations and Commentary. So you have you've got tables of cases on, I'll show those in a minute. You've then got the main pieces of legislation and basically annotations to it by these eminent people and commentaries. There's the table of cases, a lot of them, of course, running all the way through there, large number. Then the statutes, and then after that these SIs, which you've got the statutory instruments. Then after that you've got various other insolvency practitioner reference material, and you've then got an introduction to the actual book itself, which is always worth reading because it'll give you some idea of where we start. And of course a very factual statement. Our starting point in this book is the Insolvency Act 1986, where it's got to be, because that's where the legislation emanates. Then we go straight into the Act itself, and then it sets out how it's organised, and then you've got the various commentaries that go with the pieces of legislation. And I think it's absolutely fundamental to have this if you are involved in any contentious insolvency. And in fact there are quite a few cases now where the actual method of insolvency and what actually happens is actually not agreed. So there is quite a substantial amount of dispute between the various people involved within insolvency practice itself, not just the courts but all the other people involved. And therefore you do need to have both the actual words in the rules and the Act together with a view as to what they mean. And I certainly have found this helpful with some of the recent cases I've had where there have been clear disputes on some of the things that have happened. And one of the concerns I have, and I think a lot of other people have, is that there is a need, probably, for a law commission to review the whole of the way in which insolvency works. Certainly sometime in this century, I'm sure that will happen. The trouble is, it's like everything else. These ideas are wonderful, which the Law Commission and others have, yet nothing's done, and things just run along and along and along. Meanwhile, the books and the cases expand the books out of all proportion. Before we know where we are, this will be a 2-volume work, and you see therefore what the difficulties are. The view very clearly is a little bit more simplicity would assist. What do we say about the book? Because as you gather, I like this book immensely. It's been helpful to me, and I'm sure it will be to you as practitioners. If you're an insolvency practitioner, you'll welcome this new 5th edition from Jordan Publishing of what has become, we say, an indispensable legal text. Here in one single volume, you have everything you need to provide reliable, knowledgeable advice to insolvency clients and to argue cases convincingly in court. And that's in fact the benefit of this. I have seen this book quite regularly on the shelves certainly in the county courts where I mainly practice. It's heavy but handy, and it's a reference work of well over 2,000 pages, which provides all the relevant key legislation, both primary and secondary, together with key statutory provisions and case law. The result of what we have here is a practical guide put together by 2 expert authors, Lewis Doyle and Professor Andrew Kay, who head an impressive team of contributors. I've mentioned their names, well in fact shown their names very briefly in the introduction. As the authors explain, the starting point of this book is the Insolvency Act 1986, which provided for the unification of 2 pieces of legislation: the Bankruptcy Act for personal insolvency and the Companies Act for corporate insolvency. The Act therefore resulted in a major reform of insolvency law in the United Kingdom. The date, 1986, so it's 40 years old. It's also pointed out, however, that while personal and corporate insolvency are contained within this statute, a truly unified system per se remains an elusive goal. That is really what I'm alluding to as well, in that I think there has to be a proper, complete review of where we're going with this legislation and the whole mechanism of insolvency as we enter a new era in business, information technology and so forth. And as is commonplace, a body of legislation is hardly ever straightforward, as is certainly proved throughout this book. In other words, you've got to look at the words and try to work out what the meaning is of what Parliament has said, because that is really the role of the judges and what we do as advocates in addressing the particular points in, say, a specific rule or a section of an act. And this is the book that helps us do that. So it's reassuring that this new edition provides all of the legislation and case law pertaining to the corporate, personal and cross-border regimes that have emerged since 2014, in particular the approach by the Court of Appeal to the IVA regime, which is again an important point to bear in mind because of the number of IVAs available, and of course much more, including the changes implemented by the Small Business Enterprise and Employment Act 2015 and the very important Deregulation Act 2015. Other issues covered include, and this is only a partial list from what's actually mentioned at the back, validation orders, wrongful trading law, private examinations, and rather importantly you might say, the treatment of proof of debt in creditors' meetings, and that can sometimes cause a lot of problems in its own way. Here then is an unwieldy and massive subject, the complexity of which is revealed in what is, again, I use the word again, massive volume. Proof positive that insolvency legislation is, in the opinion of many, in dire need of further reform. Fortunately for the more than occasionally bemused practitioner, the clarity with which the commentary is written and the logical organisation of the book's contents make it an essential work of reference for academics and judges, as well as insolvency lawyers. And certainly I think this is a boon for everybody involved in this area. Do also note in my conclusion that this distinguished title is available, as I say, as part of Jordan Publishing's Insolvency Online service, which you can find all the details about on the web, and it provides updates 3 times annually, so that will keep you as up to date as anything in this day and age with what is happening in the world of insolvency. So professionals in this field, we think, we would call this excellent value for money. The publication date, as I say, is cited at 2016. Let's just have a quick look again at it There's the front. It's a heavy book, as I say. I use the word massive twice, but it is a heavy book. There's the back, and you can see there's a little bit of information about the cases and various other things right at the back. And of course it's an e-book as well. You've got the, just opening it in the middle. Again, this is the Insolvency Rules. Again, most important because one does have to refer to them, and you can see again the rule is set out, and then there's a it's annotated with the commentary on a general note quite often, and the scope of the provision and any amendments which have taken place. So you are getting there, I think, a very important service from Jordan's. I'd like to thank everybody involved, the contributors and the two editors, and all the people at Jordan's, for another excellent publication for us. It just makes our lives so much easier as practitioners. Thank you. Bye-bye.